The top story, the Western Cape High Court has set aside South Africa's proposed nuclear agreements with Russia, the United States and South Korea. The court called the agreements unlawful and unconstitutional. Earthlife Africa and the Southern African Faith Communities Environment Institute launched the case in October 2015. The rights group ELA and SAFCEI launched the court application in October 2015. They accused government of flouting democratic processes by not debating the proposed nuclear agreements in Parliament. They said the Energy Department acted unlawfully when it decided to move nuclear energy procurement to Eskom. ELA and SAFCEI also said that former Energy Minister Tina Joemat-Pettersson did not follow public participation or consultative processes before making that decision. The government had defended its signing off nuclear understandings with Russia and several other countries. Former Energy Minister Tina Joemat-Pettersson had said she was not aware of any rule or court order that prevents handing of the nuclear procurement process over to Eskom. Government argued that it hadn't signed a commercial deal with Russia, but an agreement to work together. Government said an international agreement was not constitutionally required to be debated in Parliament. Government further said that the nuclear program is a policy direction that is adopted. Now, joining us on the phone line is Dr. Calvin Kem, the CEO of Nuclear Africa. Good afternoon to you, and thank you for joining us here on ANN7. First and foremost, what will the impact of this judgment be?
Well, Abigail, I don't think it's too great. I would just like to also point out that I'm also the chairman of NECSA, so I'm speaking in that capacity as well.
Thank you.
There are a number of agreements that are in existence between South Africa and these other countries, such as Russia and the US and so on, over and above these ones that are spoken about now. So NECSA is proud of the fact that we've been having dealings with Russia. For example, we've manufactured certain nuclear chamber components and exported them to Russia, which we're proud of, and we don't see any effect being impacting on that. As far as this other thing is concerned, it's a very strange arrangement because the argument from the anti-nuclear lobby is that there's no debating proposed agreements, not debating proposed agreements in Parliament. That's odd because there are no agreements yet. What there was a number of deals with various countries on technological foundations on which to talk. You know, you can't be dealing with one country, like, say, the US, if they're dealing in feet and inches and we're dealing in centimeters and liters and things like that. So there's fundamental exchange agreements that took place to say, do we operate from the same page in the approach to what we plan to do in the future? And that is what has been done. There's no procurement deal that's been done. There's no move towards purchase. What happened was in December last year, an RFI, which is a request for information, was submitted jointly by Eskom and by NECSA, and that was to ask people to come along and again explain their approach to localization, their approach to training, maintenance, all the things that we need to know before we go ahead with the next phase. All that has been done. It's been done correctly as far as I'm aware, and I was personally involved in a number of the public participation processes that have been going on for years now around these things. So I can't see what public participation there is when professional nuclear scientists and engineers are talking to other professional people about details of design of technological base. Surely that is not carried out in the town hall. So I don't really understand what's going on. I'm not a lawyer. I haven't seen any legal judgment, and I would need some interpretation of that. But I don't see it as any particular major snag at the moment because everything else we've been doing has been done correctly as far as I'm aware.
Dr. Kem, I'm not sure as to how aware you are of the arguments that's been put forth, but do you have any comment with regards to the arguments put forth by ELA and SAFCEI and the government?
Well, they've consistently put forward arguments for years now that there's been secret deals for procurement signed behind the scenes. I'm not aware of any such deal, and I'm involved intimately with this. And we just don't do that. It's an insult to the integrity of the South African professionals in the nuclear business. There are South African professional nuclear scientists like me and professional nuclear engineers, professional accountants, economics people, and so on, all involved. And as a group, we get down together and we come to the decisions on what it is that we need, what type of engine, for example, in the system, how this whole thing must work, and that goes through multiple spirals of decision-making to come to the conclusion of what it is South Africa needs to acquire. This is all done within the framework of affordability and so on. These accusations that we would somehow spend money we don't possess is quite crazy. We don't do that when we build dams, build solar, build wind, build gas, build anything. Why would we suddenly do it with nuclear? The people that do these things are professional people with integrity. So these constant accusations, which are just largely smear tactics to my mind, are very misleading. And unfortunately, people believe things like the R1 trillion number, and they believe things like little planning is done, and so on and so forth. And that's plain and simply not true.
Thank you very much, Dr. Kemp, for unpacking those details for us and sharing your views with us as well. That was Dr. Kelvin Kemp, the CEO of Nuclear Africa, as well as the chairman of NECSA, just giving us his views and some comments with regards to the nuclear judgment. Stay tuned to ANN7 for the latest details and developments.